We'll hear argument this morning in Case 13-1433, Brumfield versus Kane.
Today's date is 1/12/93. The time is 2:15 p.m. The present location is City Police Detective Office. This is a statement on the file number 1824. That of a homicide of Officer Betty Smothers. Those present are Sergeant Wall, Detective Callahan, Baton Rouge Police Department. Also, Kevan Brumfield, operating a video camera, is crime scene officer Corporal Betty Smothers. Also present is Detective Dennis Kohler, narcotics. Kevin, you're under arrest for first-degree murder, and I'm going to go over with you what your constitution was. You need not make any statements that you have the right to remain silent. Anything you say may be used against you in trial. You have the right to consult with and obtain the advice of an attorney before answering any questions or making any statements. Do you understand that? Do you understand? If you cannot afford an attorney, the court will obtain one to represent you and advise you. Do you understand that?
Yes.
You have the right to have your attorney or appoint an attorney present at the time of any question or give you any statement. Do you understand what I just read to you?
Yes.
You wish to sign this statement I read to you before I sign the name. Slide it right here. How far in school did you go, Kevin?
12, I graduated.
You graduated from 12th grade? And what kind of grades did you make in school?
A's and B.
Was that in 1 year or all throughout each?
13 years.
Pretty intelligent. And you willing to make a statement concerning what happened?
Yes.
Okay, on January 7th.
Yes.
Okay, in your own words, tell us what occurred when you used names, use complete names, so we know who you need to speak up.
Around 10:30, January 6th, me and Henri Broadway and Smoker were, we were talking about hit a hustle. That's what I call about hit a hustle, is rob something and take something. And we was drinking, so we excluded to the scene. We shifted and waited for Officer Smothers and the clerk from the grocery store to come drop the money and trust the bank. And so once we seen her, jumped out the car. I jumped out the bushes, and she like seen me. So I started shooting, and Henri started shooting also. And about that time, Smokey, he was behind the bank in the car where he could see us. So we shot, and the lady looked like, somebody, she was just trying to get away. But at that time, I didn't know that Officer Smothers had been hit and killed. And the store clerk was driving the car. So at that time, we jumped in the car, we went down Jefferson. And at that time, we seen the police car pull in at Circle K. which proved I was saying, man, I know I ain't killed him, man. And then we went back on Prescott, Moheed, and they had some guys downstairs at this time. And I told them, I just told someone, a guy named Peter and Ron, to watch my back while I leave. At this time, no one knew what happened except me, Ray J, and Smoke. I jumped the fence and went around on the corner of West Boostown. And after that, I went and got my brother's car. I went and picked up my girlfriend, Deshaun, and we went and got a room. At about 2 a.m., I took my brother in the car, and I had one of my cousins, Eric Yarbo, to drop me off at Shedran Hotel.
Mr. Chief Justice, and may it please the Court. The decision of the state court in this case was to deny Kevan Brumfield a hearing on his claim of intellectual disability. That decision was based on an entirely unreasonable determination of the facts of Brumfield's mental condition. The first basis given by the state court was that Brumfield scored a 75 on the Wechsler IQ test. That's not just suggestive of intellectual disability, that's actual evidence of intellectual disability. And there was no testimony in the record to the contrary. The second basis for the state court's decision was that the defendant has not, quote, demonstrated impairment based on this record in adaptive skills. To demand or even expect that blood from the stone of a pre-Atkins record where neither intellectual disability nor adaptive skills were even raised,
I'm sorry,
patently unreasonable.
I don't, whether I agree with you or not, isn't it your burden to prove that he had some deficits in adaptive ability? You have to make the threshold showing.
Yes, there's a threshold showing under Louisiana law.
So what did you show that met that prong in any way?
Sure. The standard under Louisiana law is a low one. It's a burden of coming forward with some evidence of objective facts that put the movement's intellectual disability at issue.
Is your point that we are involved in a wholly different inquiry once Atkins is on the books? Because when you were before the state court at the sentencing hearing, you weren't talking about intellectual disability.
That's correct.
You were talking about some mitigating factors. So the state court never had before it an Atkins claim. An Atkins claim is raised for the first time on post-conviction review.
That's exactly right. It's similar to the reasoning that this Court adopted in Bobby v. Buys. And in precisely this setting, the Louisiana Supreme Court held, or it explained, that prior to Atkins, as Your Honor just explained, a defendant only had to show diminished capacity as a mitigating factor and wasn't called upon to marshal demonstrations of intellectual disability or impairment in adaptive skills.
Do you not think it would have been ineffective assistance of counsel pre-Atkins for a lawyer who had a client who was severely mentally disabled not to bring that fact forward in the sentencing hearing for consideration by the jury?
Your Honor,
even though it wasn't, a mandatory federal basis for exempting him from the death penalty, surely you would want the jury to consider that kind of evidence, wouldn't you?
Your Honor, this Court in Henri and again in Atkins recognized that putting on a defense of quote-unquote mental retardation, as the term was used at that time, is a double-edged sword. It's a much higher burden, typically, than the lower burden of putting on mitigating evidence of one's mental condition. First, it was evidence before the state court judge that Mr. Brumfield had a fourth-grade reading level in terms of mere word recognition, not even comprehension. That's, again, actual evidence of impairment in adaptive skills. It was in the record before the state court that Mr. Brumfield, quote, has a basic deficit somewhere in his brain. It was in the record in the state court that he had a very low birth weight that put him at risk of neurological trauma. And it was in the record from Dr. Bolter that Mr. Brumfield was in trouble many, many, many years ago. The second expert before the state court, this is in the state court record, was Dr. Gwynn. She was a social worker. She didn't perform any tests of her own, but she found that Mr. Brumfield was sent to, quote, special education from the 3rd grade, that he had been placed in and out of mental hospitals because no one knew what to do with him throughout his childhood and youth, that his main problem was that he cannot process information the way normal people do. And that's precise. That is a key indicator of intellectual disability that this court recognized twice in Atkins. She testified that Brumfield, before the state court, she testified that Brumfield needed someone to, quote, help him function, that he did poorly even at recess as a child because he couldn't function with a lot of chaos around him, that at age 11, one of the mental institutions in which he had been placed, quote, questioned his intellectual functions and noted his slowness in motor development, and that the nurses, literally from his birth, recognized that there was something wrong with him and that he was slower than normal babies.
Am I wrong in my understanding that the record included an expert report stating that Brumfield possessed, quote, a normal capacity to learn and acquire information, and that he had, quote, adequate problem-solving and reasoning skills? Is that correct?
Your Honor, if that's I believe that's from the report of Dr. Jordan. Dr. Jordan did not testify in the state court proceeding.
What makes your case different? Why, in your case, can't the state rely on the evidence in the penalty phase, if that's what you're relying on to make your sum showing?
Once the defendant comes forward with some evidence, which Mr. Brumfield did here overwhelmingly, if there's contrary evidence in the record, that's what the hearing is for. I would break it down this way. The question of whether an individual is intellectually disabled, this court left to the states under Atkins. So the state standard is what applies for the showing that a defendant must make in order to prove his intellectual disability at the hearing.
So what is the broader significance of the question you want us to decide, since you've conceded that the answer to the first question presented is no?
No. I'm sorry. I certainly did not mean to concede that the answer to the first question presented is no. My answer to Justice Alito's hypothetical was if there is uncontested evidence in the record disqualifying intellectual disability.
Right, but your question is, if it's determinative, is it unreasonable? And Justice Alito gave you an example of where it was determinative, and you said it was not unreasonable. So as a general rule, the question is the answer to the question is no. And in terms of what we're going to decide, I just need to know whether it is simply whether the facts in your particular case lead to a particular result, or if there is some more general legal rule that you're arguing for.
Section 2254d2 is on its face and by its text a factual inquiry. And this Court need do nothing more than rule that what this judge did in this proceeding on this pre-Atkins record was unreasonable.
Go back to Justice Kennedy's question. And we're either working it backwards or working it forward, but you're not taking it step by step, okay? So is your first argument that there was enough evidence for you to have been entitled to a hearing?
That certainly is part of our argument, but it doesn't explain the entirety of the federal error cognizable under federal law under Section D2.
Why don't you tell us you said that in the state habeas there were 3 things that were unreasonable.
Correct.
So tell us what they were.
So the first, this is on pages 171 and 172 of the petition appendix. The first was that Mr. Brumfield had an IQ score of 75. We know as a matter of clinical fact that that is evidence of intellectual disability. The second prong articulated by the state court was that Mr. Brumfield had not demonstrated impairment in adaptive skills. This court, the Louisiana Supreme Court, have all indicated that because Atkins changed the playing field, it is unjust and unreasonable to look to a pre-Atkins record for that determination. However, the record from that pre-Atkins trial and sentencing was replete with evidence which the state court never mentions in his decision.
I thought the former was the question you sought to bring before us, namely that the state court couldn't use it at all, period. I mean, question one that you presented in your petition is as follows. Whether a state court that considers the evidence presented at a petitioner's penalty phase proceeding as determinative of the petitioner's claim of intellectual disability under Atkins has based its decision on an unreasonable determination of the facts. Whether a state court, any state court, not this particular state court, but whether any state court that makes its decision based upon a pre-Atkins penalty phase hearing is automatically has automatically made an unreasonable determination of the facts. Wasn't that the question you presented?
We did not intend the question presented to sound more like a legal question that would become a matter of law.
Did it include, that's what it sounds like.
But I thought your case included the following. Atkins says you cannot sentence to death and execute an intellectually disabled person. So Mr. Smith, whose case is not final, says to the judge, Judge, I would like to produce evidence I am intellectually disabled. The state says, no, you can't. That would clearly violate Atkins, wouldn't it?
Correct.
Now, suppose it says, yes, you can't. Now, we don't have in Atkins a standard which says when you do and when you don't have to state, let this person present evidence. We don't say it. But the state has found one. The state of Louisiana has a standard. And I take it if that's a good enough standard, that's what we should follow. And that standard from State v. Williams says, we will give you a hearing if you, Mr. Smith, provide objective factors that will put at issue the fact of mental retardation. If you will come forward with some evidence to put your mental condition at issue. And so I guess unless we think Louisiana can't use that standard, that standard is good enough for federal purposes. And therefore the issue is, did your client and you put forward some evidence to put your mental condition at issue? And as long as you came forward with some evidence, then unless we're prepared to write some new federal standard for when you have to give a hearing and when not, that's the question. And you're saying, among other things, of course, Judge, as you're telling us, of course we put forward some evidence. In fact, we think we put forward a lot more. And we would have put forward a lot more if the hearing hadn't been pre-Atkins. Isn't that your argument?
That is correct. That is our argument.
So let's get to
so clearly.
Well, I think that's important that be your argument.
Well, I don't want to intrude.
It's important if it really is your argument. And it is.
It really is our argument.
Yes.
I don't want to intrude too much on your rebuttal time, but as the case has been argued, I think you're making a strong argument that is purely a factual argument about this case.
Mr. Chief Justice, I'll reserve my time for rebuttal.
Thank you, counsel. Ms. Burns?
Mr. Chief Justice, and may it please the Court, I would like to just begin by recapping that what is at issue here is whether the ultimate factual conclusion that was made by the state habeas court was it reasonable and entitled to epidefference under whatever viable support was available in that record. The magistrate judge on April the 15th of 2008, in her recommendation to the district court, which was in fact adopted and signed off on by the district court, found that there was in fact failure to put forth objective factors in this case, and that he should not have been given an Atkins hearing.
The standard, that's what I think. Of course, you can't know whether it's unreasonable or not unreasonable unless you know what standard you're trying to meet. And my impression is, and that's why I went on at length, you heard what I said, and it's really to you, just want to be sure he adopts it. The standard seemed to be the standard. You are entitled to a hearing, says Louisiana, indeed a new one, if you meet the standard of State v. Williams. And that seemed to me good enough to be a federal standard in the absence of any other. Now, am I right about that or wrong?
The cases have held that for funding or for
forget funding for the moment.
There must be sufficient factors set forth, objective factors, not mere conclusive.
No, I agree with that. I just want to know factors to show what. And am I right in saying, in the absence in Atkins of any standard about when you have to have a hearing, that the State standard is good enough? What he wants is a hearing. He doesn't want us to — he'd like it, but he doesn't want — we don't have to say whether this person is intellectually disabled or not. He wants a hearing. And there is nothing in Atkins that says what the standard is to give him a hearing. Therefore, I looked at the State standard from Williams and thought that's good enough to serve as a federal standard. Now, am I right or wrong?
The standard is under deference to the State and to the State of Louisiana and to our mental retardation, intellectual disability statute, that there are three prongs.
No, you're not answering my question. Of course we defer to the State. Yeah. And we defer to the State when it makes what judgment? The judgment you, Mr. Defendant, are not entitled to a hearing. So what's the standard under which they decide whether he's entitled to a hearing or not? And I thought it's State v. Williams. Am I right or am I wrong?
The failure to meet an adaptive prong, you have to put some evidence forward.
Excuse me, are we going around in a circle, a little bit of a circle? It seems to me that if what happened here was the right thing, the federal court went back and said, did the State properly preclude this petitioner from putting on or discovering evidence? Did it improperly fail to hold a hearing? And the court there said, by the courts, by any standard, there was some evidence, certainly by the State standard, but even by a constitutional standard, there was some evidence of incompetency. He was entitled to a hearing. They didn't give it to him. So now I will give him the hearing because this is federal habeas. And in fact, we have said if a State improperly precludes you from developing a claim, then there is no deference owed to the State. So what we're really looking at was the federal hearing properly granted? You did not argue that on the basis of the evidence produced at the federal hearing that this man was not intellectually disabled.
You should look at both of these issues. You look at AEDPA, and if you should find that there should have been a federal hearing, then at that point we ask you to look to the fact that he did not make a preponderance case, which they made a preliminary finding of in footnote 8.
That isn't, at this moment, I'll put it once more and see if I get an absolute definite answer from you. And I'm overstating. But if I had to decide at this moment whether there is enough evidence for you to win on the point, is he intellectually disabled, I would say you win. If I have to decide whether or not he presented enough evidence to get a hearing, I would say you lose. Now, that's why it's important to me to know, are we trying to decide here whether there was enough evidence such that the State, under federal law, was unreasonable in not granting him a hearing? There I look at the standards of Williams, and I think you lose. If we're deciding something else, like whether he's intellectually disabled, and I'm repeating myself, I think you win. That's why I want your answer to the question of which are we deciding, or both.
The point is that no evidence, not one adaptive deficit was ever presented
but
in
Ms.
the
Burns,
state habeas.
Ms. Burns, I think what Justice Breyer is driving at is just this. And reasonable people might disagree on the answer to this. But I think, the determination that the state court was making at that moment was whether to have a hearing. And under Louisiana law, I don't think you disagree with this. I don't think anybody could disagree with this. Under Louisiana law, you have a hearing when the defendant has come forward, and the burden is on the defendant, but when the defendant has come forward with some evidence that raises a reasonable doubt as to his mental capacity. That's the standard that's in Williams. It's repeated again and done. You don't disagree with that.
I do not, Your Honor.
And so what Justice Breyer is suggesting is that when we realize that that's the determination that the state court is making, whether the defendant has come forward with some evidence putting his mental capacity at issue, it looks awfully like an unreasonable determination of facts to say that this record does not meet that standard. That's all that the case is about, isn't it?
I would disagree respectfully, and I would also ask this Court to remember that the Court here looked at the entire record, and that is
the point. It seems to me that's the point you have to attack. Does the state saying that there has to be some evidence, does that mean if there is one item of evidence, even though it's outweighed by everything else, it's contradicted by other witnesses, if there's one little peppercorn of evidence, you have to go on to a hearing? Is that what the state rule means, or does it mean when you consider the entirety, including the rebuttal evidence? Is there reasonably some evidence of his mental disability?
Justice Scalia, it is the entirety of the record.
I cannot
underscore that. The first thing that the state did at the sentencing hearing was to reintroduce the 41 witnesses who testified, their testimony, as well as the 159 exhibits that went into the very sophisticated, premeditated planning of this crime.
Wait a minute. Then there is a legal question here. And the legal question is, can a state make the final determination of mental incapacity or lack thereof based on a trial record that did not address the issue? That was the question presented. And you're saying it can, and what your adversary is saying, if there is some evidence of mental incapacity, then I'm entitled to a separate hearing that addresses that question alone. I can put in additional evidence and contradict whatever happened at the penalty stage. That's what his point is. Why is he wrong?
Justice Sotomayor, if I may disagree with that, the rationale of this Court in Atkins is that we are an evolving, decent society that will not have a consensus to execute mentally retarded people. That falls in the face. That falls in the face of saying that juries then are inclined to execute them if they show some evidence of mental retardation.
I think we're all on the same page here, and I think we've made some progress in this, because I agree with you, and I agree with Justice Scalia, that what we have to do, and there isn't to, is to look at the whole record and see, keeping in mind the fact that it was a pre-Atkins record, and they didn't know about Atkins, but looking at the whole record, is the Louisiana court clearly wrong? Is it unreasonable in saying there wasn't enough evidence, even though there has to be some, which is up to them, pretty much how they say the sum, but they're unreasonable in saying that there wasn't some evidence justifying a hearing. And the only way to do that is for us to read it. Is that right?
The record has to be read.
Would you agree with that?
I would agree that the entirety of the record has got to be read. It cannot be taken in a vacuum, as counsel would have you believe that this judge was myopic.
I haven't read the whole record, and I doubt that I'm going to. And I doubt that this Court is going to read the whole record in all of these Atkins cases in the future. I mean, what you're asking is you don't think it's fantastical?
I do, Your Honor, and that's my whole point, is if you make the argument that in every one of these cases where mental retardation was not raised as an issue, it opens the floodgates for every Atkins case to have to be reexamined, to have to be given a hearing.
No, not everyone. You want to do this one.
The petitioner's counsel conceded that if in this hearing, at the sentencing hearing, medical evidence was that, in the opinion of the expert witness, this defendant has no intellectual disability, this would be a different case. That's not in this case. And what is in this case, and you have still not answered Justice Breyer's question, echoed by Justice Kagan, don't we look at Dunn and Williams to see what the standard is? And
Absolutely.
You have not said yes, and you have not said no.
Yes, that is the law.
All right.
But that still requires him to come forward with not just some evidence, but significant factors. This individual was examined 5 times. Prior to the age of 18, he was given a whisk. Nobody found the words intellectual disability. In fact,
of course, because Atkins wasn't decided.
No, mental retardation has existed since the beginning of time. It does not require the Atkins case to come into play. Nobody found him to be intellectually disabled. What they did find was conduct disorder, hyperactivity, under-socialized, aggressive, and then as an adult that morphed into antisocial personality behavior. They are also two separate and distinct items, and that is contained in the Louisiana statute on intellectual disability, that certain things like learning disabilities, environmental, cultural, or economic disadvantage, emotional stress in the home or school, difficulty in adjusting to school, behavioral disorders, and other mental types of behavior, psychoses, are not necessarily indicative.
Thank you, counsel.
Thank you, Your Honor.
Has anyone promised you anything in exchange for this statement? Forced you to make this statement? Is this statement of your own free will? No one, I haven't had foot on your toe or anything like that? That concludes the statement. The time is 2:47 p.m., same day, same person.
Why don't y'all sign the sheet and we'll tag that picture?
Before we go off the tape, why don't you sign your name up here or on the last down here? Sign your name right there here. Today's date. And I'll put my initials, date, and lower left corner.